Welcome to Elle Said What? And this is the second and final version of From Baldwin to Brady. Alec Baldwin's manslaughter charges were dismissed. The trial court dismissed the charges with prejudice. Those charges cannot be brought against Alec Baldwin again by the state of New Mexico. And I wanted to give a brief history of what led to the what's called the Brady rule or Brady information that eventually led to Alec Baldwin's manslaughter trial being dismissed with prejudice. Now, part one ended where John Leo Brady is has been transferred from Miami back to southern Missouri, and his co-conspirator, Donald Boblet, the brother of his pregnant girlfriend, Nancy. Remember, John Brady is in love with Nancy, who, by the way, is married to Slim. Hi, Susanna. Thank you. So once John Brady is back in the same county jail with Donald Boblet, who had given four confessions, denying that he had not done anything actively in the robbery and murder of John Brady's grandfather's farmhand. Once Donald Boblet learns that John Brady is in the same county jail, he decides to give a fifth confession. And in the fifth confession, what Donald Boblet confesses to matches what John Brady confessed to the FBI about the robbery and the murder of William Brooks. Well, one thing to note is that the fifth confession wasn't signed. And you're probably wondering, what does this have to do with Alec Baldwin? There's no confession in the Baldwin case. Well, that fifth confession that actually matched John Brady's confession, John Brady's defense team was never knew about that fifth confession until after the trials and until after John Brady's appellate process and his post-conviction hearings had been exhausted. So Brady went on trial first. He took the stand in his own defense. Brady told the same story that he told the FBI, which is that his intention was to rob a bank and that he and Donald Boblet wanted to rob this bank using the victim's brand new Ford Fairlane. Is a Fairlane a Ford? The vehicle was a Fairlane. About a week after, well, let me back up. So not ever denied participating in the crime. What Brady denied at trial was the active participation in the murder, that he did not strangle the victim to death, that Donald Boblet did that without his encouragement, that Donald Boblet did that against his objections. And so when it comes to the sentencing phase, Brady's attorney tells the jury that his client is guilty of first degree murder, but should not be sentenced to death. But what the jury has are the is overwhelming evidence of first degree murder, cold blooded murder. John Brady had known the victim since he was a child, and they robbed the victim after or during, after killing him or in the course of murdering him. And so John Brady was sentenced to the gas chamber. He was sentenced to death. The jury made that decision without knowing about the fifth confession that Donald Boblet made. So, about a week later, Donald Boblet went on trial. Boblet also took the stand in his defense, and Donald Boblet stuck to the first four confessions. Basically, I didn't do nothing. It was all John. Well, the jury also sentenced Donald Boblet to death. Donald Boblet was reportedly stoic, no emotion. His mother burst into tears. While in the county jail, Nancy, pregnant by John Brady, went to see her brother Donald. She stopped by John's cell and she asked him, "Did you kill that man?" And John Brady said no. Reportedly, Nancy did not ever speak to John Brady again. She and her family blamed John Brady for 100% of the crime that her brother Donald was convicted of. Donald would appeal. His appeal would be denied. Was Donald put to death? The last time I checked, Donald Boblet, as of 2013, was still in a Missouri prison, 79 years old. That was over a decade ago. So, how do we get to Alec Baldwin and what is Brady information? Well, eventually, John Brady's defense team finds out about the fifth confession. And John Brady's defense team appeals. And they appeal, and the appellate court agrees with Brady. And the appellate court says that, yes, that Brady's jury should have known about Donald Boblet's fifth confession, and that the prosecution not turning over evidence that a jury could possibly use to decide not to give the defendant the death penalty was tantamount basically to suppression of evidence. And so the appellate court said that Brady could not have a new trial because the evidence is overwhelming. Brady confessed. He said on the stand at his trial that his confession was not coerced in any way. And he said the appellate court said that, but what Brady could do was get a new sentencing hearing. Well, Brady's attorneys were not satisfied with that. And good thing that Brady's attorneys were not satisfied with that, because that's how John Leo Brady's case ended up at the Warren Court, at the Supreme Court of the United States. John Brady's defense team appealed to the Supreme Court of the United States, stating that it was requesting John Brady receive a new trial because Brady had been denied due process by that fifth confession not being handed over to the defense before trial. Well, the Supreme Court listens to arguments on both sides, and the Supreme Court ultimately agreed with John Brady. Now, let me explain something to you. At this time, in the state of Missouri, the jury not only decided punishment and guilt, but the jury decided the law. And the Supreme Court of the United States paid a lot of attention to that, because juries don't decide the law. I am sure that has since been corrected in the Missouri Constitution. Missouri and the state of Indiana had that in their Constitution. But the state of Missouri, but the Supreme Court of the United States wanted to know from Brady what the jury instructions were. And I asked in part one, if you were on the jury and there was evidence, there was an assertion backed up by two corroborating confessions from co-defendants that Brady did not actively participate in murdering the victim, would that sway you to vote for Brady to get life in prison versus the death penalty. Hey, too big. So I'm going to try and play something from you all where Brady's attorney is being questioned by a Supreme Court justice.
They were instructed at page 42 of the record that they...
The Supreme Court justice wants to know, what was the jury instructed? And you're going to hear from Brady's defense attorney that the jury actually could have convicted John Brady of a lesser count of murder, which would have taken the death penalty off the table, most likely. Have a listen. This is Brady's defense attorney telling the Supreme Court of the United States what the jury instructions were.
Could find the petitioner guilty of murder in the first degree without any restrictions on the punishment, guilty of murder in the first degree without capital punishment, murder in the second degree, manslaughter. It's at page 44 of the record, the first full paragraph beginning in the middle of the page. 5 possible verdicts: second degree manslaughter and acquittal.
Don't we have to disagree with your court's statement as to the...
Did you all hear that? There were 5 different degrees of murder that John Brady's jury could have considered. And so had Brady's jury gotten Donald Boblett's 5th confession, which corroborated John Brady's confession, that possibly could have swayed one or more jurors and changed the outcome of the verdict, which was guilty of murder in the first degree, and the punishment, the gas chamber. By the way, Brady's attorney saying at trial that his client did not deny being guilty of first degree murder when the jury instructions had lesser degrees of murder, I think was irresponsible. But can I deny that this attorney is a rock star? No, he got Brady to the Supreme Court, and we got an Alec Baldwin is included in that the Brady rule. So the Supreme Court of the United States came back and decided that not only does the government have a duty to turn over to the defense any information that is helpful, possibly to the defense, that regardless of whether or not there is intent to withhold that information is considered suppressed if the defense does not get it. And it's a violation of constitutional due process rights, which means that the defendant gets back into an appellate court and most likely will have the verdict thrown out. Violation of a constitutional right, the due process right, the constitutional right to a fair trial. John Brady did not have a fair trial because the jury did not have all of the evidence. Now, a lot of times you'll hear exculpatory evidence, and you'll say that's evidence that can clear the defendant, that can prove that the defendant is innocent. No, that's not what exculpatory evidence is. It's evidence that may exonerate the defendant, may not. It's up to the jury to decide how they want to deal with the facts presented in front of them. But what we get from John Brady is not only does the prosecution have a duty to turn that information over, and it is inexcusable if the prosecution says, sorry, accident, didn't realize that it wasn't turned over, that makes no difference. Same result, suppression of evidence, violation of due process. The Supreme Court of the United States also decided that the police have this duty that while investigating a crime and the prosecution, the government will continue to have police investigate a crime all the way throughout a trial, that the police also have a duty to turn over what is now called Brady information. And that is why you saw the sheriff, the judge in Alec Baldwin's case, questioning the sheriff about the ammunition that turned up after Baldwin's trial had already begun. Because the police have a duty just like the government does to make sure that this type of information makes its way to the defense. Well, that explains why the sheriff testified. Now you also understand that the special prosecutor, well, listen to what the special prosecutor has to say. The judge, I knew it was over. I knew it was over, by the way, when the special prosecutor in Baldwin's trial got on the stand.
It would have been the best evidence I could have hoped for.
Ammunition turned into the sheriff's office in the Rust case and not turned over to Alec Baldwin's defense team leads the judge to dismiss his case entirely.
To bad faith is to show signs of scorching.
Could this decision impact Rust?
You hear the judge? Shows evidence of scorching. Judge came just shy, in my opinion, of accusing the state of intentionally neglecting to send that ammunition over to the defense. And just because Baldwin's defense team discovered that evidence at the beginning of his trial does not mean that Baldwin's due process rights were not violated. And once that has happened, unfair trial, it goes out of the window. Because one of the Brady rules is that Brady information has to be turned over in a timely manner, meaning before trial. So, Brady information, what are the takeaways from Brady? Brady information is information that may exonerate the defendant, information, the punishment if the defendant is found guilty, material impeachment of the government's witness. What is material impeachment? Meaning, I can challenge what that witness just said as untrue, as a lie. I've got a fact, a question, a fact to present to throw back at what that witness just said to show that that witness is either lying or uninformed. So, any evidence that would support a valid defense is considered Brady information. And according to the Supreme Court of the United States, if it is not turned over in a timely manner, then that is a violation of the defendant's due process rights. Alec Baldwin's trial, his manslaughter charge, John Brady's felony murder charge, Donald Boblett's felony murder charge, all of those cases were bigger than any one defendant. We are all protected by the Brady rule if we are accused of a crime. We all have the right to due process, to a fair trial. So in a 5-2 decision, Supreme Court, like I said, sided with Brady and stated that the withholding of evidence violates due process where the evidence is material, meaning it could sway a jury one way or another. If there is no jury, it could sway the judge one way or the other. Either to guilt or punishment. So I'll say that again. Withholding of evidence violates due process where the evidence is material, either to guilt or punishment. So, what's the aftermath? The aftermath is The Supreme Court of the United States agreed. I'm sorry, I've been seeing Missouri throughout this live stream. It's actually the state of Maryland. Sorry. But the Supreme Court of the United States agreed with the state of Maryland. The evidence is overwhelming. There's no need to give John Brady a new trial. But he does deserve a new sentencing hearing. And Brady was sentenced to life in prison versus the death sentence that he got at his first trial. And what happened? What happened to everybody? I told you that, his love, Nancy, never spoke to him again. She gave birth to a son. John Brady never spoke to his son. Brady was eventually released from prison. He moved to Florida. He became a truck driver. He got married. He started a family. And he didn't ever, to anyone's knowledge, commit another crime. And as of 11 years ago, John Brady's co-defendant, Donald Boblet, who, according to Brady and Boblet's fifth confession, strangled the victim to death with his own shirt, was 79 years old in a Maryland prison. So I'd like to thank everybody for stopping by. And I hope that you understand what I was trying to get across in these two live streams. Sometimes if you can connect a story to the law, it makes the law easier to understand and easier to remember. So Alec Baldwin is free because the government did not turn over Brady information. Information where evidence is material, either to guilt or to punishment. So I'd like to thank everybody who stopped by to watch this live. Thank you, Too Big. Thank you, RB, Susanna. Hello, El Jorges. And check out part 1. And if you like history and American jurisprudence, check out the shorts that I have on Ernesto Miranda and learn how we obtained Miranda rights. Have a good afternoon, have a great night, and have a great tomorrow. Don't forget to hit the like button.